Hello, I'm Alette Ace. I'm a practicing attorney in Pretoria, South Africa, and this is the first episode of the legal podcast, Lunch Hour Law. This is my dog Charlie, and I have a cup of coffee here. The reason for Charlie and my cup of coffee is just to indicate that this is a very informal discussion on a topic that I have found may be helpful to other people looking at this podcast. This is by no means formal or professional legal advice, and if you do find that you have a real legal problem or that you would like more information on your legal problem, please consult an attorney. One of the topics that I have recently come across in my legal practice, and it's been the case every few months, is loan agreements. Now, loan agreements sound simple. One person borrows money from another, and an agreement or a contract is then put in place to ensure that that money is paid back. When I speak about loan agreements, I do not refer to taking a loan at a bank. So this is particularly in respect of two private people. For example, someone is not doing well financially during COVID-19, which is very it's a very good example, I think. And you would like to assist that person, whether it be a family member, a friend, a colleague, and you two agree that you are going to loan that person money. There are certain things that need to always be in that contract for you to make sure that you are covered. Again, the topic of a loan contract is a very extensive topic, and there are hundreds and hundreds of clauses that could actually go into that contract. But the point of this episode or of this discussion is to make sure that you are aware that certain really, really basic things need to go into that contract to make sure that you are covered. Let me just take a sip of my coffee. All right. So, I'm quite a visual person, so I have attempted to print out certain small posters or pages. Oh, there we go. Charlie is now relaxing. To try and assist us in our story to make sure that you can take something away from this when you think about borrowing and loaning money. So, in our story, you are loaning 100,000 Rand to a friend, family member, someone that has approached you to say, I'm really struggling. So in our story, in our example, there's a 100,000 Rand that's being loaned. Okay. So the first thing we need to know about this 100,000 Rand is this is what we call our capital debt amount. Now, I've recently taken over a file from a client that was at a previous attorney for 2.5, 3 years. And one of the things that really jumped on me when I went through this very thick file is that the one thing that seems to be always in order in a loan contract, and then in the summons, unfortunately some people need to sue to actually enforce this contract, is the capital debt amount usually is in place. So somewhere in this written contract, people know, and you should also know, to specify the total amount that you've actually loaned. So that's the capital debt amount, right? The next thing that we need to specify in our written loan contract is our monthly repayment. So our repayment terms are very important, and the more specified they are and the more detailed they are, the better for you, because we always imagine that it may become necessary in the future to enforce this contract. And if the contract is then vague or open to interpretation, it causes unnecessary legal issues and unnecessary problems for you when you try to enforce this contract. So it's important that we be very specific. So in our story, we say that you and your friend have now agreed that this 100,000 Rand capital debt amount will be repaid in monthly installments of 5,000 Rand. Right. On top of the amount being specified, the monthly amount of 5,000 Rand, we can also say it needs to be paid by a certain date. I know that the maintenance court, for example, is very fond of the date of 7th by or before the 7th of the month, but this is really open to what you want to do, but make sure a date is linked to it. So let's say 5,000 Rand needs to be repaid into a certain bank account, which you'll also specify in your contract, by the 30th of that month. Okay. You need to look at that I found is not always in loan contracts, even if attorneys draft them. So you would be surprised about how many attorneys forget to add certain basics into this contract, is our interest. So you've now obviously helped your friend or your colleague tremendously by giving them this loan. And to make sure that you are sufficiently compensated for inflation over time, because you'll only get this 100,000 Rand back over time, you need to add interest to it. There are various types of interest, and in this instance again, it could be a case of doing what you want. So it's a custom-made contract, and you can decide. There was a delivery, also a reality in COVID-19. So the last aspect we were speaking about was our interest rate, and I was saying that you can custom make the interest rate, but there are certain pointers that you may want to consider when you ascertain what your interest rate should be. The two main indicators that I like looking at for interest is either the prescribed interest rate, which is an interest rate that appears in the Prescribed Interest Rate Act, and that is from time to time obviously changed. At this stage it's 7% per annum, which is quite low. At some stage when I just started practicing it was 11, 12, 13% per annum, so it's really been low quite a bit due to COVID, etc, etc. Okay, so that's one possibility. If you're unsure at what interest rate your friend should repay this loan, you can always look at that act and you can actually Google it. Prescribed Interest Rate Act. The other possible indicator that you can have a look at if you want to look at interest rates is the Consumer Price Index. Now, the Consumer Price Index basically in short is the power of a household to actually purchase certain basic goods. So a typical household in South Africa will, according to this interest rate, have a certain purchasing power. So it's a way to make sure that you are paid back and that you are also compensated for the inflation on that amount, so that you don't get back less than 100,000 in the end. Okay, so the next poster then would be, let's say in your loan contract, you've now decided on 7% interest per year. Now, the interesting thing about 7% interest per year is if we look at it per month, it would be 583 Rand per month. Now, why is this important? In law, for more than 100 years, but particularly also incorporated into the National Credit Act, which is something we'll speak of separately later, there is something called the in duplum rule. It's a Latin phrase that basically means double amount rule. The double amount rule simply means that to protect the person borrowing the money, so that's not you in the story, that's your friend. We need to make sure that interest cannot just accumulate over time until it's actually more than the capital debt amount. We never want a scenario where the interest and, for example, costs are more than the capital debt amount. That would be, in terms of the in duplum rule, unlawful. Now, to actually make sure that the in duplum rule is applied, one ensures that in terms of the monthly repayment amounts, that it's first applied toward interest and then toward the capital debt amount. So that, and this is from my side, I think the most important aspect of this entire podcast today. The reason I say so is the example I referred to earlier with the client's file that I took over, as well as another file that I'm helping someone with that is in Cape Town. In both instances, learned colleagues of mine, these are practicing attorneys, make the very same mistake. So I can only imagine that the public at large would not necessarily know this either. So the next aspect, which I think might be the most important of this entire discussion, is what we call the acceleration clause. An acceleration clause, in my mind and in my opinion, should go into any loan contract, right? So what is it and why do I say so? In our example, we will, for example, in your loan contract with your friend say, if your friend misses a single payment, for example, August 2021 comes and goes and they fail to pay 5,000 Rand into your account for the loan for the month of August. If that happens, then we specify in terms of the acceleration clause that the entire outstanding loan, any interest and any costs, become due and payable immediately. All right. So we accelerate the fact that the rest of the loan becomes due and payable. Now the term due and payable, another term that, on the topic of an acceleration clause, I mentioned a very important term just now, being that money becomes due and payable. Right. So the next poster is due and payable. Due and payable is a very intricate, very extensive, very technical legal term that I will by no means cover at this stage. All I want to say about due and payable is that the acceleration clause assists greatly to ensure that the entire loan that's outstanding at a certain point of time becomes due and payable to you immediately if your friend misses any installment. So, back into our example. Your friend misses the 5,000 Rand payments for August, September and October. You decide you want to consult with an attorney and the attorney drafts a summons to start enforcing this contract against your friend. So you're basically claiming outstanding monies from your friend because they've now missed 3 months installments to you. If we did not have the acceleration clause in your contract, then only the months of August, September and October, 3 months, would have been claimable in your summons, in your legal action. So you would have been, in effect, entitled to claim 15,000 Rand from your friend for the 3 months that they missed. With the acceleration clause, however, we now accelerate the fact that the entire loan becomes due and payable immediately. And we ensure that if your friend has now missed these 3 months on our example, that you can proceed to claim the entire 100,000 Rand that's outstanding, or the part that may be outstanding of this 100,000 Rand, let's say 95,000 Rand, plus any interest that's still outstanding. So let's say you can then claim, in terms of the legal action that your attorney helps you with, 96 or 97,000 Rand. Let's say that then includes interest. So the acceleration clause takes you from a point where you can only claim what is, in terms of a timeline, outstanding at that particular point in time, to taking you to a point where you, due to this breach of trust, due to this breach of contract, can basically claim everything in terms of the loan that is outstanding. It becomes due and payable immediately due to that breach, due to that default. What I saw from the 2 instances these past few months, both instances that I basically took over from other attorneys, is that in both instances the attorneys got it wrong. Neither of those 2 loan contracts actually had acceleration clauses in them. So the attorneys assumed that because there was a default, because there was a breach, you could automatically, necessarily claim everything that may be claimable in future. In other words, the entire loan must be claimed for their client, when in fact there was no acceleration clause. That was wrong. So upon speaking to these attorneys and canvassing this topic and this aspect, they then agreed, yes, it is in fact wrong, and they had to redo the summons at the cost of the client in both instances to only claim what was in time due and payable up to that stage, which was, for example, 4 months or 6 months that the borrower fell behind. They could not, in fact, claim the entire loan amount, basically only because there was no acceleration clause in these loan contracts. It's such a simple thing to include, and it's such a boilerplate clause. It's such an easy copy and paste clause that attorneys can easily include in your loan contract for you. If you are going to draft your own loan contract, because it's quite an informal sort of arrangement between you and the friend that you've borrowed money to, please make sure that you get a template or an example of an acceleration clause off the internet to see what wording you should actually end up using. But to me, the acceleration clause is a beauty of a mechanism that's so easily included and that can really assist you to stop the whole arrangement, to stop the whole timeline over years of waiting for repayment if you see the person has started defaulting. And so it's a big frustration then to having to wait and claim only the few months that they've fallen behind with, when in fact you could have claimed everything. Right, so that is the saga of the acceleration clause, and from our side, what I think maybe one of the most important aspects of a loan contract, something so easy to include. We have covered very, very basic aspects and very basic tips in this short discussion, but in summary, when you do borrow money or when you loan money to someone, please make sure firstly there is a written contract. Verbal contracts are enforceable in this instance, in the context of a loan contract or of a loan, but it is always easier, once again, to be able to refer to something in writing rather than he said, she said. Remember, the contract is in place when things go wrong. While things are going right, that's fantastic. You don't need legal assistance. You don't need to enforce it. But once something goes wrong and your friend falls behind and starts defaulting on these monthly payments, it's always better, obviously, to have a written contract that's clear and that has certain clauses in it. In terms of this written contract, we said the capital debt amount must be specified. You can either do a separate definition saying capital debt amount, colon, etc. This is what it is, 100,000 Rand. Or you can have it as a separate clause. I like it as a separate clause saying, here's your introduction, this is who the parties are, their friends or family, whatever. And the one party is in need of 100,000 Rand in our example, the other party is able and willing to lend and advance that 100,000 Rand, and then the next clause I like usually having the heading capital debt amount. So that was our first main aspect. The second thing we spoke about was the interest rate, and we said there are various indicators that you may use. You can always go higher than what the prescribed interest rate is or what the consumer price index is, but those are indicators that usually seem fair to both parties. So you can use them, you can access them easily online, and you can add that interest rate then into your loan contract. The next thing we said, and you need not specify it or write it out in your loan contract, but it's something to keep in mind that you must know applies throughout to this arrangement, is the in duplum rule, which in Latin means double amount, as we said, which long and the short of what you should understand from that is to say that any money received monthly in terms of this loan from your friend must first be applied toward any interest or cost, but in this example it's only interest, and thereafter to the capital debt amount, so that we don't have an instance where the interest becomes higher or more than the actual 100,000 Rand, which is our capital debt amount. That is never allowed. It was not allowed before the National Credit Act, and it's specifically not allowed in terms of the National Credit Act either. Again, just keep the idea of National Credit Act on ice for a moment. We'll talk about that right at the end. So that was our interest rate, and that was our in duplum rule. The next thing we spoke about, which from my side I really do think is one of the most important, most underrated aspects of any loan contract, is our acceleration clause. And coupled with that is the idea of debt becoming due and payable, right? So we said due and payable is usually on a timeline. For example, the friend that has now borrowed the money from you has fallen behind with 3 months in our example. So only 3 months would be due and payable, except if you have an acceleration clause. So the acceleration clause then accelerates the rest of the loan and any interest up to that point that's outstanding and makes all of it due and payable. So you can then approach your attorney and say, I would like to claim everything outstanding back because my friend has defaulted on 3 months. Right, so that was the acceleration clause and the idea of money coming due and payable and how those two interact. The last aspect that one needs to mention or touch on in terms of loan contracts, one cannot finalize this podcast without touching on it, is the National Credit Act. The National Credit Act is a piece of legislation. It's a 2005 act. Some parts have been enacted earlier, some parts later. It's a very technical act. There are a lot of legal practitioners that specialize in corporate or commercial law that are able to draft legal papers to enforce loans or outstanding money in terms of the National Credit Act. The point is it's not an easy topic to discuss informally, and it should not be, in my mind, discussed informally as part of these tips and these quick aspects that we're speaking about here now. But what you could maybe take away in terms of the National Credit Act is to know that in recent years, case law and courts have basically mostly extended the scope and the ambit of the National Credit Act. So where in the past, let's say when the Act just came out 15 years ago, 16 years ago, was very limited in terms of what it applied to, it's been rather extended in terms of its application and scope. So it basically applies to much more now than what it did 15, 16 years ago. The reason for my mentioning this is I've also seen quite a few instances where two parties are of the opinion that the National Credit Act does not apply. They're very convinced of this, and in the end, when the attorney starts enforcing the contract and starts drafting legal papers, it then comes as a big surprise to either the lender or the borrower that in fact the National Credit Act must apply. So when the National Credit Act applies, it has a big bearing on how we enforce this contract, how we get in the debt that needs to be collected, how we draft the legal papers, all kinds of different legal hoops that one needs to jump through to actually enforce the loan contract. Again, in context of financial institutions and banks, we generally see that the National Credit Act does apply because we have the arm's length between the parties. It's not a family member or friend, for example, but there's a whole test that must be done to see if the National Credit Act applies, and your attorney, if they're worth their salt, will know this and they will apply these aspects of this test to see whether or not your loan contract falls within the scope of the National Credit Act. But yes, as I said, the National Credit Act is actually worthy of a whole discussion by itself, and it's not something that I think the public at large needs to know of in particular. It's something that a legal practitioner that takes on a case that involves credit should actually know and should apply on your behalf. Just remember, if you are kind enough to extend and to advance money to someone in these difficult times, keep in mind these aspects that we spoke about during these few minutes. There's a lot more to be said about loan contracts, and it's always best to obviously approach an attorney and to make sure that they draft something in writing on your behalf. But if you would like to actually do it by yourself, or if you'd like to make sure that your attorney is doing what they should be doing, keep in mind these few clauses that we spoke of to make sure that if things go south, you are able to actually enforce the entire loan contract and get all your money back at once, not having to wait bit by bit, piece by piece. Thank you so very much for watching the very first episode of Lunch Hour Law. I hope that there's something out of these few minutes that would have been helpful to you. I hope that it was informal and informative enough that you would like to watch the next episode. The idea is to upload very short, useful and relevant topics every few weeks. I'll see as and when new topics arise in my legal practice, things that I think may be helpful, tips that may be helpful to you. So there's no set timeline as to when the next podcast will be uploaded, but I hope that something else will dawn on me in the next while so that I can then touch on that next. So this is on YouTube, as you know. Feel free to share it. If you are a legal student or a student of law, please do not see this as a legal lecture. It's by no means sufficient or extensive enough to at all constitute a legal lecture. You will fail. But just as an ordinary human being that may find themselves in a role where you either borrow or lend money, keep these small things in mind. Hopefully they have helped you. So from Charlie and myself, thank you so very much again for tuning in and watching the first podcast. Please stay safe, sanitize, please isolate, and thank you so much. I'll see you at the next episode. Okay, bye.